So, hello everyone who is in person now, the ones that will be coming very soon, the ones that are online. Welcome everybody to this 2025 edition of the Sports Arbitration Moot. We're very happy to have you here. Most of you probably know us, but just for you to know, on my right I have Sofia de Sampaio Hayes, on my left I have Julio Palermo, and I am Celia Cañete. We are the co-founders of the Sports Arbitration Moot. We want to very briefly give you like some ideas, some insights on this year's edition. So for those of you who don't know us that much, when we started this project 4 years ago, we wanted to create a competition that allowed students from all over the world to learn sports law in a way that everybody could participate, no matter their financial situation, the political situation, what they were. We just wanted teams who had a computer, internet, and a lot of willingness to learn. That's how we created this. And over the years, this started growing up a lot. We created the CIAM camp, which the students know because it's a 5-day cross course with lecturers that many of them are then arbitrators, and they give them the tools to prepare the case, so they don't need their university to have specific classes on sports law. Then we started bringing students. Here is proof. We have 16 teams this year, but when we started, we had 2 teams that went to Zurich. And also we created the CIAM conference, which will be afterwards. We'll be joined by many practitioners from all over the world. And last but not least, we created the CIAM award competition for those students who wanted to go like the extra mile and also do a writing exercise. And now the result is this is the people who are watching this on YouTube. We created a CIAM community. We see many faces that we know. We see many other new faces. And we're very happy to have you in our CIAM community.
When we first created the CIAM, we thought that we would be very lucky if we had 10 teams joining the competition. And this year, we are very proud and a bit amazed to see that we have 70 teams that registered in the competition from every single continent. 16 of those teams are here today. They hail from 10 different countries, and I'm going to name them all just so you can see the diversity: from India, from Pakistan, from China, from the US, from Canada, Australia, the United Kingdom, Norway, Singapore, and Spain. So thank you very much, everyone, for making the effort to travel and be here with us today. But this remarkable growth did not just happen by chance. It is the result of a lot of team effort from the whole community, and we would like to express our sincere gratitude to all of the CIAM arbitrators who dedicate their time and expertise to hear the students and offer their feedback. To the CIAM camp lecturers who prepare the students for the competition and share their knowledge. To the Moody's and the coaches, obviously, because you are the heart and soul of this competition, and you are the testament to the very promising future of sports arbitration. To the CIAM ambassadors who promote the Moot throughout the world, and of course to our very generous partners and sponsors who make it possible to provide financial aid for a lot of the teams to be here, who supply us with the venues and the platforms, and who really act as a support system for our team as well. And finally, a heartfelt thank you to all those involved in organizing the CIAM, our moderators of the general rounds, who are a lot of people who give their time for free, the venue hosts, the designers, the photographers, the videographer, and every single person working to make this event a real success and memorable for all of you.
Thanks a lot, Sophie. And I just want to thank, when people tell me, oh, have you done this? At the beginning I did something, and actually I'm doing nothing. And what you see is the result of the effort of an amazing team. Without them, the countless hours that I've spent on this pro bono, nothing of everything that you see would be possible. And I would like to thank, first of all, Christelle and Julia, that are the ones that are putting like incredible amount of effort, energy, and hours in this. Thanks, and really. And then I wanted to thank the rest of the team. There are some newcomers, and we have people that are with us since the beginning. I wanted to thank indeed Alessia, Gael, Clemence, Paco, Thomas, Nitish, and I hope don't forget anyone. And then I want to thank my co-founders for having trusted that this could have been an incredible project. Yeah. And then I wanted to especially thank Antonio Rigozzi. He supported this initiative since the beginning through the University of Neuchâtel. He tried to do everything to be with us here, but he couldn't make it, and we really much look forward to see him next year. Same applies to Ulrich, that for different reasons, unfortunately, he couldn't make it last minute, and we also look forward to see him next year. Now I will move to introduce the arbitrators of the final. First, we have Lynn O'Leary. She's an academic, very prominent CAS arbitrator, was arbitrating this year at the ad hoc Olympic, and she was, since the beginning of the competition, also a coach. So she knows very well our competition. Her teams were extremely well prepared, and we are very grateful for whatever she's done so far. Then I wanted to introduce Annette Rombach. She's one of the most prominent, or the most prominent CAS arbitrator of our generation. She's also an arbitrator at the Basket Arbitral Tribunal, and she's also a very successful arbitrator in commercial arbitration. Extremely well prepared, always with us since the beginning. Thanks a lot for everything you have done. Last, but obviously not the least, Jose Maria Alonso. For the very few of you that don't know him, he's the president of this amazing arbitral institution that is hosting us for the third year. Before that, he was the managing partner of top Spanish and international arbitration law firm in Spain. It's the former president of the Madrid Bar Association, the biggest bar association in Europe, and is currently the president of, as I said, this amazing arbitral institution. He's a CAS arbitrator, and on top of being a CAS arbitrator, is one of the most experienced arbitrators that I know in commercial investment and sport arbitration. Thanks a lot for accepting our invitation, and I wanted to ask Jose Maria if you can give a few words of welcome on behalf of the institution, and I invite also Annette and Lynn to join him, so that then we can start the final. Thanks again.
Welcome all of you to the Madrid International Arbitration Center headquarters here in Madrid, in this beautiful palace of Santoña. Apart from this, we have another 3 offices in San Jose of Costa Rica and Sao Paulo in Brazil, and very recently in Santiago de Chile. For us, it's an honor to host this final in the Sports Arbitration Moot, and welcome all of you here. It's very young, but probably now is the most important moot in relation to sport arbitration. So I must congratulate the 3 founders for doing such superb work. And if now you have 70, I've heard participants, well, we have the blue sky ahead of us for the next competition. Just a few words about what it is, the Madrid International Arbitration Center, that was set up in 2020 by the 3 main arbitration courts in Spain, and who decided to transfer all the international arbitration practice to this new entity, the Madrid International Arbitration Center. Afterwards, the Madrid bar, being myself the dean, decided to join, and very recently, the Court of Arbitration of Santiago of Chile joined as a new partner to this super project. Why this court was set up? Well, if you look at the statistics of the ICC, between 20 and 25% of the arbitrations, commercial arbitrations that are started every year have an Ibero-American party. When I speak about Ibero-American, I'm referring to Portugal and Spain, and from Rio Grande to the Patagonia. So we are a real power in the world in terms of arbitration. So we decided that it had very little sense that those arbitrations have the seats in New York, in Miami, in Paris, in London and Geneva. With all my respects to those cities, because are great cities, but they don't speak our language. 2 of them are common law countries. And here we have the same language, the same legal system, or very similar, a very strong arbitration community, all the necessary premises, and we have to say that we are cheaper. And that is very important in terms of arbitration costs. I became a CAS arbitrator, coming from the commercial arbitration and the investment treaty arbitration. And what I found is that probably the amount involved is smaller, but the legal issues are more beautiful. I have discovered that we are talking about sport arbitration, but sport arbitration includes labor law, civil law, commercial law, sport law, and in many cases, Swiss law. So it's a combination of many laws that make all the cases extremely interesting for us as arbitrators. So what I have to say is that I encourage you to continue and to become initially counsels, and when you are older, you can become an arbitrator. Thank you.
Welcome to the hearing today at the CAS Ad Hoc Division. First of all, before we start with the official part, I would like to congratulate both teams for having made it to the finals today. It has been a long journey, and you are the two best teams at this stage already, so congratulations on that. And I can say on behalf of the three of us that we are very eager to hear your pleadings now very soon. Before we do that, let me again briefly introduce the parties to my co-arbitrators and myself. We have Ms. Leanne O'Leary as co-arbitrator to my right side, and Mr. Jose Maria Alonso, my co-arbitrator on the left side. Also, we do have a premiere here. I believe that this is the first ad hoc case that is pleaded in public and streamed live on YouTube with the consent of both parties, because we do not have a disciplinary case. And with that, and shortly introduce, my name is Annette Rombach. I'm serving as the president of the panel today. We would be ready to introduce the parties, and then as a matter of housekeeping, both of you have 20 minutes for your pleading, for your oral pleading, plus rebuttals of 1 minute for each side. So we would be ready, so I invite you to introduce yourself, and we would begin with the Appellant team, which is on my right side. Please.
Good afternoon, panelists. My name is Rebecca Webb, and I appear with my co-counsel, Stephanie Wilkes, on behalf of Ms. Azaria Stark and Mimosa Olympic Committee, the appellant in these proceedings. In the first 10 minutes, I will address issues 1 and 2, and in the remaining 10 minutes, my co-counsel will address issues 3 and 4. Thank you.
Thank you very much. Counsel for the respondent.
Dear panel, good afternoon. My name is Melissa Savamali. This is my co-counsel, Håvarsson Halvorsen, and we'll be pleading on behalf of the respondent, World Athletics, today. I'll be addressing the merits of the case, and my co-counsel the procedural issues, splitting the allocated time of 20 minutes evenly between both of us. Thank you.
Thank you very much. Then we are ready to begin without further ado, and I would pass, excuse me.
Has they made a decision on the issues, the order of the issues?
Yes. Yes, so we would be ready to start, and I would pass the floor to counsel for the appellant, please.
Thank you, Ms. Arbitrator. This case goes far beyond the lanes of an athletics track, to the very heart of Olympism, the principle of fair play. Today, the appellant's case will demonstrate that Mr. Troublebottom breached his duty as an impartial and compliant referee in an event that he should not have been a part of in the first place. And this not only deprived Ms. Stark of a fair chance at Olympic gold, but it undermines the integrity of the sports governance system. Today, the panel has two options: whether to condemn this conduct by granting the relief Ms. Stark is seeking, or to accept a diminished standard of decision-making tainted by bias and arbitrariness. One of the key questions before the panel today is whether Ms. Stark's application is admissible. And the answer to this question is yes, as she was not required to exhaust the World Athletics Jury of Appeal, which is established under our Legal Authority Number 3, Rule 12 of the Competition Rules. We refer to our Legal Authority Number 1, Article 61.2 of the Olympic Charter, which establishes the jurisdiction of the CAS for disputes arising on the occasion of the Olympics. We also refer to our Legal Authority Number 2, Article 1 of the CAS Arbitration Rules for the Olympic Games, which required Ms. Stark to exhaust all internal remedies available to her. It is our submission that the Jury of Appeal is by nature an extraordinary remedy that Ms. Stark was not required to exhaust. And to further this point, we'd like to draw a distinction between ordinary remedies, which are those that the appellant is explicitly required to exhaust, and extraordinary remedies, which are typically discretionary remedies that the appellant has the right to, but are not obliged to exhaust. And if I could refer the panel to our Legal Authority Number 4, in the works of scholars Mavramati and Reeb at paragraph 33, which states that both CAS jurisprudence and the Swiss Federal Tribunal have confirmed that this obligation applies only to ordinary remedies. And the Jury of Appeal is extraordinary due to two key points. Firstly, that Ms. Stark only had a right of appeal under Rule 8.3 of the technical rules, which states that if the referee makes a decision, there shall be a right of appeal to the jury. If it was within the intention of World Athletics that this was an ordinary remedy, there would be an explicit provision stating that the appellant must go to the jury of appeal before they can appeal to the CAS, and no such provision exists. And this aligns with the panel's reasoning in our legal authority number 5, where the panel held at paragraph 50 that there was no obligation to exhaust an internal remedy that expressly provided for a right of appeal, and where there was no precondition that there was no provision that it was a precondition to a CAS appeal. The second reason why the jury of appeal is extraordinary was because Mr. Troublebottom's advice is pronounced final under Rule 8.11 of the technical rules. And this states that the decision of the jury of appeal or of the referee, if no appeal to the jury is made, shall be final. Not only does this specific language indicate that a referee's decision is equivalent to that of a jury, but that the advice was a final and binding decision eligible for CAS appeal. And this aligns with the rationale behind this obligation, which is only in place so that only final decisions can be challenged before the CAS, and this has been fulfilled in this instance. And this further aligns with the panel's reasoning in our legal authority number 8 at paragraph 4.10, where the panel noted that the decision was pronounced final by the Appeals Commission, and therefore further internal remedies were classified as extraordinary. Ultimately, Ms. Stark should not be deprived of her right to be heard for not exercising a discretionary remedy provided for her benefit. And in order for these rules to be applied fairly, they must be applied exactly as they are written and given their ordinary meaning, which indicates that this was a discretionary remedy. And if the panel is not with me on this point, I will now move to our alternative argument that the exceptional circumstances of this matter justify a departure from the principle of exhaustion. We refer to our legal authority number 7 at paragraph 64, which states that in order for an exception to apply, the appellant must demonstrate the existence of exceptional circumstances and demonstrate the illusory character of internal remedies. It is our submission that the jury of appeal is in these circumstances illusory, and therefore Ms. Stark was exempt from filing an appeal. Ms. Stark only had 30 minutes from the giving of the advice at 21:45 to utilise this remedy under Rule 8.7 of the technical rules. And if I could refer the panel to page 17 of the case file at Exhibit 7, which is Ms. Stark's witness statement. This shows the timeline in which Ms. Stark obtained the crucial evidence that grounds this appeal. Firstly, at paragraph 10, upon discovering the deleted tweet at 22:46, 61 minutes after the advice, it was not until this point that she started questioning the integrity of Mr. Troublebottom, and this is beyond the 30-minute time frame of the jury. Secondly, at paragraph 11, upon discovering the Reddit thread that alleged Mr. Troublebottom knew Torreno from university. And finally, at paragraph 12, upon receiving the email from Dorian Linton at 8:34 the next morning. The respondent's skeleton of arguments suggests that Ms. Stark should have appealed immediately if she disagreed with the advice. And we acknowledge that Ms. Stark may have been disappointed by this advice, as any athlete would, considering that she just lost Olympic gold. However, mere disappointment is insufficient grounds of appeal. And we'd like to remind the panel that Ms. Stark is an elite-level athlete competing at one of the most important events of her career. So logically, her primary focus after the 200-metre final was on recovering and preparing for her next race, not on doubting the authority and autonomy of a referee who she had been taught through her many years of experience to trust and respect. Therefore, this remedy was of illusory character, and the panel should find that Ms. Stark's application is admissible. And if there are no questions, I will now move to issue 2 on our skeletons. And I note that the appellant's remaining submissions proceed in the event that the panel accepts jurisdiction over this matter and Ms. Stark's application is admissible. It is our submission that the mimosa footage should be admitted to the panel as evidence and attributed full weight, as it is reliable, relevant to the case, and material to its outcome. Under our legal authority number 2, Article 15D of the CAS ad hoc rules, the CAS is empowered to exercise broad discretion in determining both the admissibility and the weight of evidence. And if I could refer the panel to page 6 of the procedural order at paragraph 7. And if the panel is with me on this point, this footage is not of the race itself, but rather the immediate aftermath, meaning it is a non-technical aspect within the CAS's power to review. It shows Ms. Stark's immediate scepticism and her lodging a protest, Mr. Troublebottom entering the video review room, and then finally him returning to announce the advice. This footage is not only direct visual confirmation of the facts, but it provides the panel with valuable context to this dispute, including elements such as Mr. Troublebottom's mannerisms and his exact behaviour at the relevant time, which can only be found in this footage. Today, the panel has the task of determining whether a field of play exception applies, and this footage is useful in determining Mr. Troublebottom's exact behaviour, and in order to grant Ms. Stark a fair trial, the panel ought to consider all of the evidence in its totality. And once admitted, we submit that this footage should be attributed full weight, as it is of probative value in determining an exception. Firstly, it shows the fast-paced nature of the protest, where Mr. Troublebottom reviewed the footage multiple times, consulted other referees, and allegedly came to a considered decision within a mere 6 minutes. It provides validity to other pieces of evidence, including Ms. Stark's statement and her allegations that Mr. Troublebottom was avoidant towards her. And it shows the immense crowd involvement in the event and the pressure placed on Mr. Troublebottom to deliver a decision in favour of Ms. Tirreno, the first para-athlete to win Olympic gold. Ultimately, it is essential that Ms. Stark is not only afforded an effective means of challenging this advice, but a de novo hearing where the panel considers all of the evidence. And if there are no further questions, that concludes our submissions regarding issues 1 and 2.
I would have one quick follow-up question, Counsel. What is the legal basis for the admissibility or inadmissibility of evidence?
Yes, CAS is not bound by the rules of evidence, and under Article 15D of the CAS ad hoc rules, they have broad discretion in admitting evidence. And essentially, the panel today has no reason not to admit this footage. It was legally obtained and submitted on time. It is reliable, as nowhere on the facts suggests that this footage is biased, and it is not adduced in an abusive way or in bad faith, which aligns with our legal authority number 11, and it is not of a field of play decision, and therefore within the CAS's power to review. Therefore, it is our submission that this footage should be admitted to the panel today.
Thank you very much, Counsel. Just for purposes of clarity, so you do not ask us to look at the race itself in the video, but only at the events in the aftermath of the race. Did I understand that
Yes,
correctly?
Ms. Arbitrator. We rely on the immediate aftermath of the race, as Ms. Stark is not contesting that an obstruction actually occurred, but rather today the panel is reviewing the behaviour of Mr. Troublebottom and determining whether a field of play exception applies.
Okay, thank you very much. Please move on.
Thank you, panellists. Continuing on from my co-counsel's submissions and our overarching theme of preserving the integrity of sport, we are here today because Mr. Troublebottom breached his duty as an Olympic official at the Rosa Olympic Games, irreparably tainting the results of the women's 200-metre final. The appellant submissions on the last 2 questions before the panel will establish that this is the exact kind of case that the field of play exceptions were designed for and that warrants a review. Also, it will establish that the scope of review of the CAS extends to changing the results of the race, and that doing so will condemn the kind of conduct exhibited by Mr. Troublebottom and uphold the standards of officiating that we should expect not only at the Olympic Games, but at all levels of sport. We acknowledge that there is a high hurdle to meet when considering the field of play exceptions, and that there has never been a successful case before. However, as the evidence in this case will go on to point out, multiple exceptions are raised here, and this is the kind of case that warrants a review. In brief, Mr. Troublebottom's tweet at Exhibits 4 and 5 of the case, Mr. Troublebottom's deletion of said tweet, the relationship between Mr. Troublebottom and Ms. Torino, and the discussion overheard by Mr. Dorian Linton all point towards bias, which is an exception. The blatant and avoidant nature with which Mr. Troublebottom delivered the advice goes to arbitrariness. And finally, his failure to verify Ms. Torino's MASH before the race goes to procedural error. All three of these things are exceptions to the field of play doctrine, as supported by our legal authority number 14 at paragraph 50A. In more detail, the most primary factor here is Mr. Troublebottom's relationship with Ms. Torino from university. This involved him being her peer mentor, as confirmed by page 20, paragraph 9 of the case file. A mentor relationship is one where you want your mentee to succeed and you do your best to facilitate that success. This is unacceptable for a referee whose mentee is competing in an Olympic event, because ultimately it could not have been possible for him to maintain impartiality in that decision involving Ms. Torino. Not only is the context of that relationship relevant, but if I could direct the panel again to page 20, paragraph 9 of the case file. Mr. Troublebottom pledges that he has not had contact with Ms. Torino for at least 3 years. With that in mind, I would also like to direct the panel to page 3, paragraph 9 of the case file. That states that Ms. Torino's coach, Mr. Bobby, referred her to the State University of Mimosa, where she met Mr. Troublebottom in September of 2023. That is less than a year and a half ago. Ultimately, this means that Mr. Troublebottom has mischaracterized their relationship within his witness statement, diminishing it and exhibiting a conscience of guilt. This means that his credibility has been undermined not only as a witness, but as a referee, and it points to the overall lack of integrity that he has shown in his conduct. This consciousness of guilt is supported again by his deletion of the tweet found on pages 13 and 14 of the case file. Not only that, but within the context of the discussion overheard by Mr. Dorian Linton, an overwhelming picture of a preference for Ms. Torino is painted, and that is one that is unacceptable at an Olympic level and has ultimately deprived not only Ms. Stark, but all the athletes in the race of procedural fairness in their event. Further, not only is this bias substantiated to the high hurdle of the comfortable satisfaction of the panel today, but there is also elements of arbitrariness and of procedural error. Speaking to arbitrariness, the Mimosa footage shows that Mr. Troublebottom was avoidant in his delivery of the advice, stating no obstruction, sorry, and giving no explanation. And the procedural error, the MASH, or failure to verify the MASH, as confirmed within the case file and within Mr. Dorian Linton's email, is a fundamental departure from his obligations as a referee. The rules state that the Mechanical Aids Review Panel can instruct a referee to conduct a verification. He was instructed to do so and then failed or chose not to conduct that verification. Ultimately, a picture has been painted of the conduct that he has exhibited that is unacceptable, and it exhibits a preference for Ms. Torino that cannot be allowed. Therefore, the high hurdle that is required for the field of play exception has been met, and ultimately, in a case like this, if the exceptions cannot be met, I would ask the panel what case could possibly meet these exceptions, as this one has met multiple to the standard that is required. Therefore, the panel should allow a field of play exception, and Mr. Troublebottom's advice should be reviewable today. On this basis, I would move to issue 4, which discusses whether the panel has the scope.
Before you do move to issue 4, I just have a question. Leaving aside the field of play doctrine, We're under Article 8.11 of the World Athletics Technical Rules. It does say that a decision of the jury of appeal or of the referee shall be final. From a point of reviewability, is the CAS panel still able to review the decision of the referee?
Yes, Ms. Arbitrator, the CAS panel is able to review it. The reason that these decisions have been stated as final within the World Athletics regulations is to confirm that the International Federation has dealt with this protest and that now it is reviewable to the CAS as an external appeal option.
But it does say there that it's no further right of appeal, including to CAS.
Yes, that is overridden by Article 61.2 of the Olympic Charter and the arbitration agreement contained within the athlete's signature of their agreement to participate.
Okay, thank you.
Moving on to issue 4.
I have a question here, because you know that the threshold for the field of play exception to apply is very high. So, in your opinion, what are the requirements for it, and why do you consider they are met in the present case?
I acknowledge, Mr. Arbitrator, that yes, the threshold is very high, and generally direct evidence is required to establish it, as confirmed by our legal authority number 10. But ultimately, we have a direct, first-hand witness statement from Mr. Troublebottom containing a mischaracterisation of the relationship between him and Ms. Serino, as well as direct documentary evidence in the form of his tweet in support of Ms. Serino and his deletion of that tweet. And when viewed within the context and circumstances of all of the other available evidence before the panel, the high hurdle for the field of play exceptions has been met. Moving to issue 4, the panel's scope of review does extend to changing the race results because this hearing is de novo, and that means that the panel assumes the power and responsibility of bodies within the International Federation of World Athletics, including the Jury of Appeal and the Mechanical Aids Review Panel, which have the power to change results after the fact. Also, on the issue of whether the panel can award a gold medal, it is the appellant's submission that the IOC, according to Article 56 of the Olympic Charter, does have the ultimate discretion on whether medals are changed or awarded. However, the panel, in its discretion, as the de novo nature of this hearing suggests, may order a re-awarding of the medals as a recommendation or an advisory matter to the IOC for them to ultimately consider, and that the reason that a rerun of the race is an alternative to this is that ultimately, if the panel chooses either one of these remedies, then Ms. Stark will not be left remediless if the field of play exception is allowed.
Excuse me, Counsel, I have a question on this, and it also relates to your requests for relief. Are you asking us to award the gold medal on the basis that the advice of the referee be rendered invalid? Because if I read your request for relief, your first request for relief is the advice is invalid, and the second one is please award the gold medal to our client. But simply because we render the referee decision invalid does not mean that your client ran faster than her opponent, does it?
Ms. Arbitrator, the facts do not indicate whether or not an obstruction occurred, and we are not arguing that an obstruction did effectively occur. It is our primary submission that the advice be invalidated because of how tainted it was with bias, arbitrariness, etc. But the re-awarding of the gold medals and the rerunning of the race stems from the procedural unfairness that Mr. Troublebottom's presence at all had on the race, not only to Ms. Stark, but to all athletes, and ultimately to allow a field of play exception, but to not award one of these remedies would be to defeat the purpose of allowing the exceptions at all. And I note that my time is expiring. May I please seek a very brief extension of 1 minute to conclude?
Yes.
Thank you.
I don't know, excuse me, Counsel, I don't know if you are going to tackle this, but do you know of any CAS resolution in which the panel has awarded a gold medal or any kind of medal?
The only similar case, Mr. Arbitrator, which may deal with this sort of dispute was CAS 24, 15 and 16, the gymnastics case, where the panel awarded a change to the results and then recommended that the IOC deal with the reallocation of medals, in which they did award a bronze medal as a result of that. we are seeking a similar outcome here, as we note that is ultimately the IOC with the discretion to deal with Olympic medals. And as a result, at the very least, Mr. Troublebottom must be referred to the Athletics Integrity Unit for his conduct, as to not do so would fundamentally diminish the standard to which we hold officials, not only at the Olympics, but all levels of sport, and the IOC should be advised of a decision in this case. If there are no further questions from the panel, that concludes submissions on behalf of the appellant.
Thank you very much, Counsel for Appellant. No further questions, I believe, from our panelists. Then we would move now to the Counsel for Respondent. The floor is yours for your oral pleading, please.
Thank you. Honorary members of the panel, my name is Håvard Sani Halvorsen, and together with my co-counsel, Melissa Sabamale, we represent the respondent, World Athletics. Before starting on the issues, we would like to start by stating that we are here today to argue that we should not be here, because Ms. Stark has already protested in this case, where that protest was dealt with seriously and promptly by the referee, Mr. Troublebottom. Now, after a thorough examination of the race footage, Mr. Troublebottom concluded that no obstruction had occurred, and we argue that his decision was made impartially and based solely on the available evidence. And Ms. Stark further refrained from exercising her right to appeal that decision to the jury of appeals, and is now trying to attempt a second shot outside the World Athletics appeal system. Then, starting with issue 1, where I will present the reasons as to why Ms. Stark has not exhausted the internal remedies available to her. Because the requirement to exhaust the internal remedies is set out in the CAS ad hoc rules, Article 1, and this rule says that the tribunal does not have jurisdiction when the applicant has not exhausted the internal remedies available to her. Now, as we just heard in their pleadings, opposing counsel argues that the appeal, an appeal to the jury of appeals, is an extraordinary remedy, and because of that, Ms. Stark was not under an obligation to appeal Mr. Troublebottom's decision. But we disagree with the applicant in this regard. One of the cases that the opposing counsel is relying on, CAS 2011 A2670, expressly notes that the disputed decision in that case was pronounced as final to the applicant, and it also came from an appeals body. But the circumstances are completely opposite in our case. Only the decision of the jury of appeals is final, and it was not pronounced as final to the applicant. Because, firstly, under Rule 8.3 of the technical rules, it states that the referee if the referee makes a decision, there shall be a right of appeal to the jury of appeals. And secondly, under Rule 8.11, it stated that the decision of the jury of appeals shall be final. Thirdly, and concludingly, the jury of appeals was ready and available to hear protests during the Rosa Olympic Games. It is therefore not true that the jury of appeals represented an extraordinary remedy for Ms. Stark. In fact, if Ms. Stark actually disagreed with his decision, she would have appealed it immediately. If I now may ask the panel to go to her witness statement on page 17 of the case, on paragraph 9. Here we can see Ms. Stark's reaction to Troublebottom denying her protest. Then, on the last sentence of paragraph 9, Ms. Stark said, "He did not add anything, seemed avoidant, and I absolutely did not understand how easily he rejected my claim. So we argue that if it is actually true that Ms. Stark did not understand how easily Troublebottom rejected her claim, then she actually meant that she was obstructed by Mr. Reno, then Ms. Stark would have appealed his decision to the jury of appeals. And moreover, it is according to cause jurisprudence, inactivity on behalf of the applicant not to appeal to the jury of appeals and does not give cause panels jurisdiction to handle the case, which was confirmed in the cause case number 1211 between the Russian Olympic Committee and the International Sailing Federation. Moreover, the exception in Article 1 is not satisfied where the urgency was created by the applicant's own inactivity, which is further confirmed in the case, in the facts I just read out to you. Therefore, to conclude on issue 1, Ms. Stark has not exhausted the internal remedies available to her. Going over then to issue 2, relating to
one second, Counsel, excuse me. Just one legal question, because I'm not sure we are quite with you there. You used both the words admissibility and jurisdiction. Are you raising a jurisdictional objection here, or could you clarify the nature of your challenge, of your defense in this respect?
I mean that the appeal is not admissible and that the panel cannot handle the case because Ms. Stark did not use the remedy of the jury of appeals in this case.
But jurisdiction and admissibility are not the same.
No.
So could you explain the difference between the two of them?
Yes, we are not arguing jurisdiction, only admissibility, that the claim is not admissible.
Okay.
Thank you so much. Then going over to issue 2, relating to the Mimosa unofficial television footage and its weight, we argue that this evidence is not admissible in this case and has no legal weight. So starting with the applicable legal basis, under Article 15, litera D, the panel has broad discretion to admit evidence and can take all appropriate action with respect to evidence, both to admit evidence and deny it. Now, in determining admissibility of evidence, cause tribunals assess whether the evidence has sufficient relevance to the case or is material to the outcome. But in the present case, the Mimosa footage is neither relevant nor material because the claims set out by Ms. Stark are both that she was obstructed and that Mr. Troublebottom was biased. But the Mimosa footage does not provide information to neither of these claims. Moving on to the materiality of the footage does not show anything about the obstruction, and it also does not provide any information to the alleged bias. It does not contradict nor supplement the official video review in any material way. So for these reasons, we argue that the video footage lacks the necessary relevance and materiality, making it inadmissible in the present case. But if the video evidence should be admitted, it should be given a very limited weight because it is unofficial evidence from unofficial sources.
Just on that point, if I may, what prejudice is there to the respondent if the panel were to let this in?
Could you please repeat that question?
Sure. If the panel were to let the evidence in, what prejudice is there to the respondent? You're here today, you've had the opportunity to raise an objection, and you've had the opportunity to comment on the evidence. What prejudice is there to the respondent if the panel is to admit it?
It would be because it is not it is not material to the case, and it does not provide any new information that we already have in the case. So it does not show the alleged obstruction, which is why we are here today to argue the case. You already have the official race footage. Turning then to the legal weight of the evidence, we can first start to lay out that the official race footage is recorded under strictly regulated technical conditions, which the Mimosa footage is not. We cannot ensure that it has been tampered with. Moreover, the Rumiana Dimitrova-Neikova case stated that reference to unofficial video recordings was with much uncertainty and little precision, and which was wrongful evidence. So for these reasons, we argue that the weight of the evidence should be low if admitted by the tribunal. And I conclude my arguments with stating that the appeal should not be admitted by the panel, and it should also not admit the Mimosa footage. And I then hand the word over to my co-counsel.
Yes, thank you, and good afternoon, Madam Presiding Arbitrator, honorable members of the panel. As mentioned by my co-counsel, I will now be addressing our arguments under the merits of the case. Here we will be mirroring the structure of opposing counsel and mainly be making two submissions. Firstly, that Mr. Troublebottom's field of play decision is not reviewable by this panel, and secondly, in the event that the panel finds that it does have the competency to intervene, it should not come to an outcome that would lead to the reallocation of the medals. In terms of reallocation of time between both submissions, we will spend most of our time on the first, as it is our primary submission pertaining to the substantive matters of the case. And I'll start with this one regarding the reviewability of Mr. Troublebottom's field of play decision, where we submit that the appellant has not sufficed the evidentiary requirements for making a deviation. Now, as correctly stated by opposing counsel, the field of play doctrine is not absolute. However, the threshold for deviating is high, and the burden of proof rests with the alleging party, in our case, the appellant. And we submit that they have not reached this threshold. Now, there have been different terminology providing as grounds for deviation from the doctrine: bias, arbitrariness, breach of duty, malicious intent, which means that the test somewhat is unclear and differs a bit depending on the case, and a term has not been clarified for what threshold these evidences should meet. But to summarize the legal landscape, I'd like to refer the panel to the case of De Lima v. IAF, included as our legal authority number 18, para 10 to be exact, where the following is stated, and I quote, "Before a CAS panel will review a field of play decision, there must be evidence of bad faith or arbitrariness. In other words, the appellant must demonstrate evidence of preference for or prejudice against a particular team or individual," end of quote. Now, applied to the present case, the question before the panel today is whether the appellant has provided sufficient evidence to substantiate their claim that Mr. Troublebottom, in acting out his role as a referee, acted with a preference for Mr. Reno. We submit that they have not. And that when assessing the sufficiency of the evidence, a threshold should be established, and the high threshold for that should be reiterated. I here refer the panel to the case of the Korean Olympic Committee and FIG, our legal authority number 19, para 17, where the following is stated, and I quote, "The panel accepts this places a high hurdle that must be cleared by any applicant seeking to review a field of play decision. However, if the hurdle were to be any lower, the floodgates would be opened, and any dissatisfied participant would be able to seek the review of a field of play decision," end of quote. So the threshold is high. Now, we do acknowledge that saying that there's a high hurdle is not a term for threshold itself, so it needs to be clarified. Now, as I mentioned earlier, this has not been done particularly pertaining to the field of play doctrine, but the words used, bias, arbitrariness, does give us some indication. Now, we're not arguing that it should be as lenient as that of the balance of...
Excuse me, counsel, in relation to bias,
Yes.
From the evidence, it comes out that Mr. Troublebottom had a relationship with Mr. Reno, or they knew each other. Don't you think he was under the duty to disclose it,
There are
and why he doesn't.
Mr. Arbitrator, there are regulations for a referee to disclose certain relations between a player, regulated through the World Athletics regulations for disclosure of relations and gifts. And there's a threshold to be reached there as well, which is significant interest or conflict of interest. And it's our submission that neither is present in our case. Now, opposing counsel mainly relies on the relationship between the both, saying that it's a direct evidence that the witness statement is sufficient to provide for grounds of the nature of their relationship. If anything, the fact that he doesn't remember that he has seen her at these sporting events speaks to how he reviews their relationship. Just because they're in the same room doesn't mean that it's biased or there's a certain nature to their relationship. Now, what we should rely on, okay, not the witness statement of Mr. Troublebottom, but the uncontested facts and the procedural clarifications, point 23 to be exact, where it is stated that this was during the university days. They only met physically twice, and due to her busy days as an athlete, they were not able to meet any more than for some study sessions with a mutual friend. Now, this also dated 3 years back. Now, this was the nature that would suffice to them to a certain level having an extension, but just because we're in the same room, especially when the athletics world is so small, is sufficient to create any relation to the extent that is required, conflict of interest or significant interest. And this is their submission of direct evidence. Now, as submitting that the threshold should be that of comfortable satisfaction, we also agree that the combined nature or the cumulative weight of the evidence presented can be sufficient, but that doesn't mean that we can deviate from the rules already there pertaining to the field of play doctrine, which is that there should be a direct evidence. That has not been presented by the opposing counsel, with me now refuting their argument on his witness statement being that direct evidence. So by asking this panel to intervene by not satisfying the evidentiary requirements, they are trying to open the floodgates. I'd like to make one more point on the evidence presented, which is their argument that Mr. Troublebottom failed to check Mr. Reno's MASH. Now, if I may ask the panel to follow me to point 3 of the procedural orders, page 5. Is the panel with me? Yes. So here's a question regarding whether Mr. Troublebottom checked the MASH or not. The question being, did Mr. Troublebottom fail to verify Mr. Reno's MASH before the race as instructed by the mark review officer, or did she refuse to submit to the inspection? The answer, Mr. Troublebottom did not verify Mr. Reno's MASH. It disregards the part of the question that actually pertains to whether a request was made by a review officer, which is what would make him obliged to do so pursuant to Article 5.2 of the Mechanical Aids Regulation. So we submit that that is also not something that he was intended to do.
Counsel, I have a more fundamental concern in this respect, which has not yet been addressed in substance. What about the nationality issue? I mean, fundamentally, the referee has the same nationality as the gold medal winner. As you are aware, when we are in sports competitions, usually this is something that is avoided. It is even avoided when you look at arbitration rules that usually try to ensure that the nationalities of the parties and the arbitrators do not coincide. And now we do have this discussion, and we do have the issue that there is the same nationality. What is your response to this concern more generally?
I understand your concern, Madam Arbitrator, and especially this being an Olympics event and not any sporting event where nationality might matter a bit more. But it's our submission that Mr. Troublebottom held back his actions until after the race, and the victory laps on social media happened again after the race. So it's our submission that to the extent that he could, he held back on his enthusiasm and only expressed it after her winning the race. Thank you. And with that, it is our submission that the opposing counsel has not, to the comfortable satisfaction of the panel, provided sufficient evidence that Mr. Troublebottom, in acting out his role as a referee, that's important, acting out his role as a referee, so not what happened after, acted with a preference for Ms. Torino. And we therefore ask the panel to find that it does not have the competency to intervene in the present case.
Just if I may ask a question before you move on, does the respondent accept that, assuming we have jurisdiction, we find we have jurisdiction, and assuming the panel finds that the dispute is admissible, and leaving aside the issue of the field of play doctrine, does World Athletics accept that the panel's ability to review the decision is not precluded in any way by Article 8.11
of the technical
World Technical Rules?
Yeah. If I can just confer with the rules, please. Yes, we do adhere to the fact that a field of play decision is reviewed on the merits and not on jurisdiction or admissibility. So it does have the possibility to do that, and it's also confirmed in a Belgian case before CAS.
Okay, and thank you. I understand the issue relating to the field of play doctrine, but as I understand it, the panel has to apply the applicable law, which is obviously in this case World Athletics regulations.
Yes.
And on reading Article 8.11 of the World Athletics Technical Rules, it specifically precludes an appeal to CAS. Now that can be both a jurisdictional point and an issue on the merits. So what would be your response to that?
Yes, so then we would have to put ourselves in the shoes of the appellant, being that we're not contesting a lot of the prerequisite that you mentioned. And it is our submission that if we get to the fact that there is a bias, then an appeal to the jury of appeal would also have been tainted by that bias, so that it wouldn't just be a case of obstruction, but also a tainted bias. So if we were the appellant adhering to everything that you said before asking me the question, then yes.
Okay, thank you very much.
Now, I see that we've used 21 minutes, including the questions from the panel. May I have 3 minutes to go on to our second submission, where we argue that in the event that the panel decides to intervene, it should not come to an outcome that would reallocate the medals. And the premise here is that it intervenes by way of deviation from the field of play doctrine, so that bias or arbitrariness has been proven. Now, we do agree with the opposing counsel that once that has been allowed, the panel does have the competency to a full review, but it's the understanding of 56 that we need to look to. An article of the Olympic Charter which states that reallocation by way of withdrawal or reallocation of the medals cannot directly happen. Now, to a certain extent, we do agree with what is said by opposing counsel, also referring to the famous Jordan's Childs case, CAS OG 2415 and 2416 of the last Paris Olympics. One could question the validity of the decision as it has been appealed, and there's discussions of appeal to the Swiss tribunal, but regardless of that, our understanding of Article 56 of the Olympic Charter is that it does allow for the panel to review or allocations by way of coming to an outcome that would naturally lead to a reallocation. So our submission and contention here is that the opposing counsel has not provided anything that would lead to that. Like Madam Arbitrator asked about invalidating the race or invalidating the advice of Mr. Arbitrator. If they were to award Ms. Stark with the gold by way of reallocation, they would have to provide us with grounds for disqualification of Ms. Stark, Ms. Torino, which would naturally lead to Ms. Stark bumping up. But they've not provided any grounds for that. And in terms of invalidating the race and ordering a rerun, it's true that in the case of Dilema v. IAF, the panel did say that once bias and arbitrariness has been proven, one could lead to invalidating the race and ordering a rerun. But it's our submission that this statement was made obiter dicta without necessarily taking into consideration what would be the actual situation. So they've not looked into how this would affect the other players. And one could say that this is an Olympics event and we only have a few days to do this. But once a race is run, most players go into restitution. It's not the same, and it would be unfair to all the other players to now ask them to rerun for something that they've been training for 4 years and think is done, and the victory medals has been given out. And therefore, to conclude on our second submission pertaining to the merits of the case, we ask the panel to find that even though it does have the competency to indirectly reallocate the medals, it doesn't have the grounds to actually do that. What should it do for it to lead to those outcomes that the opposing counsel is asking for? Thank you.
Thank you very much, counsel. Are there any questions? Yes,
Yes,
Mr. Maria.
let's talk about the famous tweet.
Yes.
That the evidence shows that it was deleted 12 minutes after it was posted, no? Do you have an explanation for that, and why it was not addressed in the witness statement?
We can't speak to why it wasn't addressed in the witness statement. That goes to what Mr. Troublebottom addressed and did not address. But what we can say that it could go to the fact that it is being misconstrued the way it is in the present case, and Mr. Troublebottom may be realizing that after the fact. It's not an event that one should happen, maybe, but it's our submission that the tweet could have stayed and it would have been fine. But maybe he realized that there would be talks, like in the Reddit post on Exhibit 5, page 14 of the case file.
Just to add, but you have drafted that witness statement for your client.
True. But again, we thought that the explanation for it was so natural that there was no need to clarify.
Thank you.
Thank you.
With this, we can move on to rebuttals, and you have 1 minute each, and we would start with the appellant, please.
Thank you. Firstly, we do not contest that the jury of appeal was available on the facts, nor do we rely on urgency as an exception, but rather that the jury was of illusory character. The respondent has relied on their legal authority number 8, where the appellant had no apparent reason not to have exhausted the remedies. Ms. Stark had a clear reason, being that she did not know of any evidence within the 30-minute time frame. In this case, it's about more than just mere disappointment.
Additionally, as the panel pointed out about Technical Rule 8.11, it does classify a field of play decision. However, CAS jurisprudence has left open exceptions for cases exactly like this one, and this is an opportunity for the panel to exercise the exceptions as they were meant to be used. And with regards to issue 4, there is a possibility to rerun the race as set out by Rule 18.7 of the competition rules. And if the panel were to award a gold medal to Ms. Stark in addition to Ms. Torino being a tie, then there would be no need for a disqualification. Thank you.
Thank you very much, counsel for respondent.
Yes, to the first point, we would like to submit that if she wanted to go to the jury of appeal, again, reiterating what was stated by my co-counsel, she should have done that when she received the decision and saw it as suspicious and not clarifying enough. Now, to the second point on, pardon me, I forgot what the second point was. Just give me a second. Yes. So again, we adhere to what we said regarding a rerun, and then to the awarding of an additional gold medal, we would submit that what the panel would have to find for that reallocation to happen is obstruction, and then go to an argument on equity, which we also do submit is not possible pursuant to 147 of the Jordan Childs case, and it was not substantiated by the opposing counsel. So it's just not awarding a gold medal. You have to substantiate on what grounds.
Thank you very much. This brings us to the close of this hearing. Thank you for your interesting and very well-crafted presentations. We would now have internal deliberations, and the result of who will be the winner will be communicated in due course after or before the conference, but after the conference. Thank you very much, and again, congratulations. Both of you did a great job.
Herlig, da. Hvis det er også for sent.
Ja, fucka litt opp og...
Hello, everyone. So we're going to have a short break in order for the panel to deliberate and decide, which I know is going to be very difficult, who is going to be the winner of this edition. We'll be starting the conference after this break, and I would just like to ask you to return into the main room at 4:20, if that's okay. Thank you.